Hi, I'm Tyler Yontz, staff attorney at the North Carolina Institute for Constitutional Law. Welcome back to our series, Cornerstone Commentaries. Today you're going to hear from Mike O'Byrne. Mike is a third-year law student at Campbell University, and he is an intern for us here at the Institute. Mike is going to talk about the State Action Doctrine today. What is the State Action Doctrine? Why is it important? I hope you'll enjoy hearing from Mike on the State Action Doctrine. So Mike, tell me, what is the State Action Doctrine?
The State Action Doctrine, it comes from the Constitution, and it basically, since the Constitution protects a number of rights from infringement, however, it essentially only protects infringement from acts by a governmental entity, not from private individuals. So this is what is known as the State Action Doctrine.
Okay, and so where does this come from in the Constitution?
It basically comes from the overall text of the Constitution. All of the majority of constitutional provisions are aimed at state action or actions by the government. For instance, the 14th Amendment will say, no state shall make or enforce any law. And this is basically the structure of most of the constitutional provisions. They're all aimed at government action and not private action.
So what type of things would be considered state action?
State action is pretty much any act taken by a federal, state, or local government entity. Sometimes this is easy to tell, such as when a legislature passes a law. Other times it isn't so clear, depending on certain government officials and the actions that they take.
And this doesn't apply to actions taken by private individuals. In other words, individuals don't have claims against other private individuals for violations of their constitutional rights.
That's correct. They wouldn't have a claim under the Constitution. However, there are instances where this type of conduct by private individuals is regulated. For instance, with employment discrimination, employers can't discriminate against employees. However, this doesn't come from the Constitution, it comes from statute.
And I imagine there are several situations where it's unclear whether there is state action. How is it determined what constitutes state action in these difficult cases?
It's generally whether the particular actor is acting under an official authority. So if a police officer, whether or not what this official does is actually permitted by law, so long as they're acting in an official capacity, there will be state action.
So this might apply to, as you said, police, teachers, the legislature, departments of city and local government. Is that correct?
Correct. Any governmental entity, whether it be city council or the state legislature or anywhere in between, all the way up to the President of the United States.
And what about situations like where you have an employer or maybe a homeowners association? Are constitutional rights implicated by the decisions and actions that they take?
Generally, no. So long as your employer is not the government, these constitutional provisions don't apply. Again, like I said, certain discrimination is illegal by federal statute. However, the Constitution does not reach these claims.
And why do you think that the State Action Doctrine, it's important to let people know about this?
I think it's important just so people understand their rights under the Constitution and how the Constitution applies to certain situations that arise in their lives.
Thank you for watching. We hope you've enjoyed this installment of Cornerstone Commentaries.